Morning. Last day, huh? Goes way too fast. That every semester. Before you know it, you will all be on your way to graduating. I have students who are just yesterday. My 1L is now studying for the bar. It happens really, really quick. So at least savor the moment and try to remember it. As hard as law school is, it gets a lot harder when you're out of here. No one's telling you what to do, what to read. You're on your own. So at least enjoy the moment. I like your shirt, Carlos. I have a similar one at home. All right. It says Notorious RBG, Ruth Bader Ginsburg. It's a pun on Notorious BIG. Yeah, there it is. So, any questions? Anything in your minds? Anything lingering? No? Okay. I have about 8 or 9 of you meeting with me tonight, it seems. I'll be here till about 8 o'clock, so even if you don't have an appointment, you can show up, but I'll be here till pretty late because I want to make sure I see everyone for the end of classes. The review session will be on May 9th at 9. I think I sent you guys an email to that effect. So you have all that information. You should come to this. Surprisingly, in the past years, the attendance has been low, which never makes much sense to me because this is your chance to get questions answered. But it's, of course, as always, your decision. Okay. Any other questions before we get started? No? Okay, so let's get started. Our last topic for the semester finishes up the unit on landlord-tenant relationships. And this topic is perhaps the crowning achievement of the abandonment of the common law doctrines. This entire semester, we've studied these various common law doctrines that have been very harsh and very brutal, and which generally gave the property owner nearly complete control over how their property is disposed of and used. The case we'll study today represent the exact opposite trend, where the courts intervene to provide additional protections for property renters. So I want you to look at this class on 2 different levels. I mean, the first level is you can study as a matter of, common law, I suppose, how the courts have fashioned these various remedies. But I also want to put on your Judge Posner hats and think a little bit about economics and try to understand how is it that these sorts of judicially created doctrines impact housing. And I'm not simply talking about whether there's raw sewage dripping from the ceilings, whatever else in that awful, awful case, but also how these sorts of doctrines affect the price of housing, affect the availability of housing, and affect the ability of tenants to actually find housing, especially if they are poor. I think I've mentioned this a couple times, but if there's one thing I want you to learn from me, and one thing only, everything has a cost. Everything has a cost, and nothing is free. And when you add benefits, either by statute or by judicial decision, someone else pays for that cost. But that cost is often unseen. Has anyone ever studied, the last class, Bastiat, a French economist from the 1800s? Anyone ever studied Bastiat? Bastiat had this, oh, you did? Who are you pointing at? Oh, Brian, I'm sorry, you're not my peripheral vision. Okay, good. So Bastiat was an economist, and he had this great essay about the seen and the unseen costs, okay? And I'll use an easy example, right? You hear this one all the time. Someone goes up to a window and smashes it, right? Smashes a window in a bakery, let's say. Someone says, well, why are you upset? Baker's like, this guy just smashed my window. But then he says, well, think about it, right? You're going to now spend this money on replacing this window. And then the guy who makes windows gets all this new money. And maybe that guy who, you know, has to make this new window will buy some bread from you. And it improves the economy. You know, you're actually putting money to the economy. And the baker says, what are you, nuts? I was going to use that money for a new oven, right? And now I can't. Okay. You often hear this. If anyone ever says disasters are good because they create spending, smack them, please, smack them. They're awful human beings. Go tell the people in Katrina or on Memorial, you know, by this flooding, awful human beings. But there are always unseen costs whenever something happens. There's always unseen costs, right? The unseen cost is you don't see the oven that was never purchased. All you see is, wow, there's a brand new window. It's shiny and sparkly. So these various attempts to impose fairness and landlord rights certainly have their benefits, and I'm not trying to diminish those, but I also want you to be cognizant of the detriments of those. Okay. So any questions on that before we get started? Yeah, Bastiat was somewhat of a satirist as well. He had this great article called The Candlemaker's Petition. And the entire point was these are the candle makers. People make candles were under siege, right? Their industry was just under attack by competition. So what was the solution to the candle makers' attack? Curtains, right? If we put curtains in more houses and block out the sun, people will need more candles. Everyone's getting it, right? So he's trying to say that the enemy of candle makers was the sun, and we need to block out the sun, like Mr. Burns, right? And he's very ironic, but he used this as a way to illustrate various economic principles to great effect. Okay. All right. So any questions on that? Just a little background for your last day of class. Okay. Where did I finish off last time?
I answered those.
So are you C next or are you next? All right. Samantha, you want to tell me what were the facts said in Hilder?
Okay. So we have a woman who's living in her apartment with her 3 children and her newborn grandchild. She's paying about $140 per month. And she had to pay a $50 damage deposit, but she was offered, if she cleaned the apartment, she would get the deposit back, but she never got the deposit back.
Mm-hmm.
There's a broken window in the kitchen. She waited about a week for the landlord to fix it. But in fear for the 2-year-old, she repaired it herself. There was no key for the front door.
Mm-hmm.
And the bathroom toilet was clogged, and there's lead paint leaking on top of her child's bedroom, odor of raw sewage in the summer. The landlord promised to fix all of these things, but he never did. So this woman is just living in these terrible conditions with her children, and has a terrible landlord, but she
Good.
For the whole term of her lease.
Okay, very good. Thank you, Samantha. So, I mean, this is I think the book probably accurately describes it, a what you may call a slumlord, right? You've heard this expression before. The landlord, slumlord, whatever you want to call him, is keeping the premise in absolutely deplorable condition. I think Samantha captured it. I mean, there's raw sewage, there's paint chipping off, there was no lock, there's broken windows, there's no electricity. They couldn't even lock the door, so they had to leave someone home at all times when they wanted to go out. I mean, these are pretty awful conditions. I mean, and I think we all think that these are pretty bad. So here's now the issue. So the rent charge was about $140 a month. I did the math just out of curiosity, and that's in present day dollars about $700 a month. Let me get out of here. You don't believe me?
No, I can't believe that she would pay that for a place like this.
Well, as it turns out, I checked Craigslist for apartments in the area, and there was nothing in that range. In fact, most apartments were double that range. So, did you check it also?
No, it's just that it's expensive and $700.
Well, I mean, we're in Vermont, but yeah. But yeah, no. I just out of curiosity, I checked in Craigslist for apartments in that area in Vermont, and most apartments were double that range in present day dollars. So, she was paying, as we'll say, well below market rates. She was paying roughly half of what the market would have carried. Okay, and I mean, I'm not. That doesn't resolve the issue, but I think that will feed into the next analysis. So she walks in, pays $140 a month, and puts down a $50 deposit. And just assume, for argument's sake, I think I'm right, but we'll assume that was much cheaper than anything else advertised on Craigslist. It wasn't Craigslist then, but advertised for rent in the 1970s. Okay, she only had a $50 deposit, which again was not even a third. Norma, the $50 deposit was not even a third of the month's rent. Is that, does that low deposit strike you in any way as odd?
Yeah, I think it's just to lure somebody in.
Oh, that's interesting. So do you think, let me put it this way, do you think the landlord actually expected her to stick around and take this apartment?
Probably not.
Yeah, why do you think so? I think you're on the right track. Why do you think the landlord probably didn't expect this to actually be a long-term engagement?
Because of the way that he's keeping his property, and he's probably just getting $50.
Yeah.
From different people and move out.
Maybe. I mean, we don't know, but I think Norma's theory actually, is pretty plausible. I think that makes sense. So if I'm this landlord, right, and I have this awful apartment, I know I'm not going to actually attract people to live here long term. So I see, what's her name, Miss Hilder, walk in with her kids and her grandson, right? I'm thinking, okay, no freaking way they actually take this apartment. Let me lowball them, give them a number, and let me just keep, whatever the deposit is in the first month's rent, because we can get grossed out. Right? I mean, everyone, Norma, that sounds plausible?
Yeah.
I think that's probably right. I think that makes sense. So he gives her this really low rent. Now, the better question is, Amala recently arrived. Why do you think Miss Hilder took this apartment at this? I mean, again, just assume it's about roughly half what the other apartments in the area were, but I mean, this is an awful condition. I mean, a quick walk around would have revealed that there was a smashed window. A quick walk around would reveal that there's no lock on the door. I mean, maybe the sewage didn't pop up till later in the summer, but you can see paint chipping. I mean, you don't need to be a handyman or an expert to see that this apartment's in pretty bad shape. Why do you think Ms. Hilder then took this apartment with all these? These are not latent defects. These defects are right there, visible to the naked eye. Wait, yeah. So what do you think was going on here?
She in the sense that, at the time she really needed a place to stay. I mean, even though the roof really.
Yeah, I think that's right. Yeah, you want to add something?
Well, she also was told repeatedly and immediately that everything would be fixed. Like when she walked in, she said, "There's a broken window." He said, "I'll fix it."
Okay. So I think between the two of you, I think you guys are on the same track. So she walks in and she really needs somewhere to stay. And I think it's safe to say she probably couldn't afford something better. So landlord promises her, like I think Cody said actually accurately, okay, don't worry about it. We'll fix it. Right? So you see the setup here, right? Right? And I think the three of you, Norma, and everyone else, but there is a setup. So she walks in, and again, she sees this place is full of trash, right? Again, to your point. And Laura says, "Oh, tell you what, you guys clean up the trash, and then you can keep the security deposit. You get your damage deposit back if you do this," which she never actually did. Okay. Now, Ryan, do you think Miss Hilder, and then we can generalize, but do you think she's closely scrutinized whatever lease that she signed?
Probably not.
Is there even a written lease? Yeah, it didn't say, but I'm going to assume there was one, just because most leases are in writing. So what do you think the lease would have actually said? Do you think there are any guarantees or promises? No. The lease, assuming there is one, and I'm pretty sure there was, assume with me here, the lease probably simply said, I give you legal possession. That's it. I give you the right to be a tenant in this apartment for this period of time. I do not in any way guarantee the conditions of the premise. Okay, now, Rosa, could Ms. Hilder have negotiated and demanded, put in some conditions into the lease saying that if you don't make these repairs, I can terminate the lease. If you don't do this, I don't pay rent. Could In theory, at least, could they have negotiated these sorts of terms?
Possibly, but I don't think she was really thinking about it. Like we said, that she really needed a place to stay.
Right. So even if she could have done it, do you think that was even in her frame to even ask these sorts of things? Why do you think she would not have had even thought to ask for this? Why would that thought not even have occurred to her?
I don't want to say it in a way, but like another class, like she's not sophisticated.
That's fine.
Yeah.
There's nothing wrong with saying she's not a sophisticated customer. I mean, it's not pejorative. And in fact, I'll say even more clearly, she had studied property like you have for 3 months, right? How long did it take for you to learn these common law rules, how unfair they are? Most people, most people perhaps has a sense of, they're not lawyers, right? They say, well, if I rent an apartment, then the apartment can't be crappy, right? I think if you had polled all of your friends and family, and you would ask them, if you sign a lease, does it protect you from having a sewage-free apartment? Say, well, yeah, of course. So it's not even that she's not sophisticated. I think she has a reasonable person standard saying, well, of course, if I'm renting this apartment, especially if the guy promises to fix it, right, then it's safe to say that it's being protected. Okay? But as all of you enlightened property students have learned, the common law is a harsh mistress, and it does not afford such protections to the tenant. So unless the landlord and the tenant agreed in the lease to have certain conditions of habitability, well, then she's out of luck. She has no remedy as to the actual lease itself. So everyone get that much? Everyone with me so far? Okay, so then Pierce, what? Oh, I'm sorry, I didn't call you Hunter. I skipped over you. Did I answer the question? Good, I like when you do that. Anyone else? Okay, sorry, lost in the shuffle. So Pierce, tell me, how did the trial court approach this matter?
Well, they found for the defendant. I mean, yeah. And
They found for the defendant?
Yeah, the defendant's to pay the plaintiff.
Well, that's not fine for the defendant. That's
They found for the plaintiff.
yeah, no, you're right. I know what you did there. It's fine.
And they ordered the plaintiff to pay her a reimbursement of all rent paid and additional compensatory damages for a 14-month period.
Okay, so the first question, Pierce, if these conditions were so awful, why did Miss Hilder stay there? And not just stay there, but continue paying her rent on time as a good tenant?
Well, as we said, she probably needed it, and she didn't want to be homeless. So
Ah.
she thought, well, if he's not going to do it, I'll fix it. And eventually she got fed up and sued. Basically said, I've done everything. You owe me all this money that you should have done.
Ah, so Lauren, under the common law, before we get to this implied junk we talk about today, under the common law at least, if a tenant is in this awful condition and she just stops paying rent and moves out, what sort of claim could she raise? And we discussed this last week a little bit. What's that thing called? The case with the flooding in the basement of the prosecutor's office.
Constructive eviction.
Yes, sir. Constructive eviction. What is that?
It's where you can't access like part of the house.
Good. Yeah. So it's what would a constructive eviction claim look like? Walk me through that. I mean, with this specific fact.
For example, she couldn't use the restroom.
Yeah.
So the toilet didn't work properly.
What other room could she not use?
The bedroom,
Yeah. Why couldn't she use a bedroom?
because the flooding, or I can't remember exactly why.
You remember, Lauren?
The plaster was falling.
The plaster's falling to the crib, right? That's where her baby slept. And literally, it's probably lead paint on top of it, right? His little flaking paint chip were floating into the baby's crib at night. That does not work. So under the common law, had she simply said, "All right, screw this, I'm moving out. I'm not going to pay the rent," she could have been held harmless. right? Because it was, I think, in all respects, a constructive eviction. I mean, this is far worse than the leaking and the water and the case we had last week. The landlord says, "Oh yeah, just don't use this room." Okay. But she didn't move out. Now, Carlos, let me ask this question briefly. What would happen, Carlos, if she had moved out? Do you think the landlord would have actually cared?
Well, I don't think so. She wouldn't be paying rent.
But what was her security deposit? Would he have much of an incentive to sue her for lost rent or anything? Why not?
Because, I mean, if he sued her for bad rent, all these things would come up that he didn't do.
Well, let me ask another question. Do you think she's a good kind of person to sue to try and get money out of?
No, she didn't.
Okay, that's what I'm looking for, right? This is, as we, she's sophisticated, she's judgment proof, as we say. That means broke. And I don't mean that in a pejorative sense, right? She couldn't afford it. If he had taken her to court, right? If he had taken her to court for back rent, good luck with that. And there's only a $50 deposit, good luck with that. And oh, by the way, she could have raised all these arguments saying this is an awful apartment, I could withheld the rent. So by all accounts, had she simply moved out and stopped paying rent, nothing would have happened to her, right? He probably wouldn't have sued her. He probably would have found some other, tenant to come in and pay the deposit and leave after a month or two. But she stuck around. She needed the apartment. Whatever reason, we don't know her circumstances, but she needed the apartment for her family. Could she move somewhere else? Well, apparently not, because this is the best she could afford. She had, what, three kids, 4 kids? I mean, there's a lot to handle in this time. So the trial court, as Pierce said correctly a moment ago, awarded damages. So they first awarded the entirety of the back rent. So basically all the rent that was awarded. And they also awarded $1,500 in compensatory damages. Okay. So Sarah, what was the basis for awarding the back rent and these $1,500 in compensatory damages? What was the legal basis? In the trial court days. We'll get to the Court of Appeals in a moment.
I want to say it was the implied warranty of habitability.
Very good. Okay, Sarah, tell us, what is the implied warranty of habitability?
So I think it's a place that's safe, that's a place that's, I wrote it down somewhere.
That's okay.
Like, it's healthy, like it's just kind of a minimum standard. Let's see. Landlord will deliver over and maintain premises that are safe, clean, and fit for human habitation, all latent and patent defects taken care of, and it cannot be waived.
Okay. So you read correctly. So Sarah, let me ask you this question. What does implied mean?
It is not expressed,
Not expressed. Very good.
and it's something that the court imposes on.
Ooh, I like the word imposes. Good word, right? So, you guys are wearing the same shirt. It's straight out of, yeah. All right, 1, 2. Okay. Implied is not expressed. It means that the court inserts it into the contract. And we've used this analogy before, but it's as if the court took a red pen and scribbled in warranty of habitability, right? Now, the parties could have reached this agreement, but I think we discussed this a moment ago, that this was probably not a sophisticated party, and this is probably not something that Ms. Hilder even thought that she would have to negotiate for. So the district court, or the trial court, I'm sorry, relied on this implied warranty of habitability to award back rent and also compensatory damages. Now, the court doesn't explain how they reached $1,500. They kind of make that up. And ultimately, the court reverses on that ground. You need to explain how you came across specific costs. You can't simply throw a number out of thin air. So that's an error. But the Supreme Court of the state embraces this implied warranty of habitability. And they say that now going forward, that this is a law of Vermont. One small note, Carl, is it necessary for the courts to be the branch of government that creates this warranty inside commercial leases or residential leases?
It's not necessary. The state governments could.
What branch are we talking about here?
The legislative branch.
The legislative branch. Imagine that. Statutes, right? Just dwell on this fact for a moment. And this is noted in the book. A number of states have judicial decisions that created this implied warranty of habitability. A number of states have legislative acts, statutes, that imply the warranty of habitability. And a handful of states have neither. Carl, what are some of the perhaps pros and cons of a judicial versus a statutory implied warranty of habitability? Questions I usually don't ask you in property because we usually don't have statutes to talk about, but indeed we do today. Pros and cons.
Definitely. A judicial implied warranty of habitability, it provides protection to people who wouldn't necessarily know the law.
Mm-hmm.
So if it was, so for example, if statutes required that the warranty must be placed in the contract, it kind of eliminates the need for the tenant, the layman, to know the law. So it kind of puts a duty on the actual lessor.
Well, Jose, let me ask you a follow-up question. Let's say that both the judicial decision says we're implying this warranty, and then the statutory thing says we're implying the warranty. So in both cases, Jose, they're implied right into the lease. What happens in the pluses and minuses of having a statute versus having a judicial decision?
Maybe the statute's more clear.
What do you mean statutes are more
Because
clear?
you can actually find it easier.
What do you mean find it?
Like you can look into the code.
Oh, I can look in a case book. You guys read this case. It took only a few minutes to read the case, right? What's the big deal? You're actually on the exact right track. You're about to give me the answer I'm looking for. But what's the big deal?
It'd be harder to search for the rule.
Well, assuming the law book here and the case book's there, the same library. What's the bigger advantage? I thought you were going to give it to me between a statutory approach and a judicial approach.
Well, I know that judicial approach could be changed. To,
I thought you were there, Jeremy.
I guess going off what you said, I guess maybe like a statutory approach would be. I guess it'd be easier for the layman, the non-lawyer trained person, to be able to understand it.
Why? You're really close. Why?
Why? Because it was created by the legislature, voted by the people.
Well, that's true for democratic accountability. I appreciate that answer, right? Cody, why would the statute be easier to read? I think you guys are on the right track right here.
I was more, I don't know. I was more focused on, I think, the latter, the democratic.
Well, okay, so tell me about that. Like, why? What's the benefit for a democratic accountability angle, which is exactly true?
I think there's two parts to it. First off, it can be more narrowly tailored or even broadly, but it's more specifically as to what the people wanted. Elect specifically the decision makers in those cases. And I think it's a little bit more easily changed because you can change the legislature every time the legislation every time the legislature meets, whereas this way you have to wait for a case that's relevant.
Sarah, read first again the definition the court gives the implied warranty of habitability.
Landlord will deliver over and maintain premises that are safe, clean, and fit for human habitation.
Okay. Jonathan, what does that mean? Sarah read it. She read exactly what the court wrote. She's 100% correct. What does that mean? Safe, clean, habitation, what was it?
Safe, clean, and fit.
Safe, clean, and fit habitation. Okay, what does that mean?
To me, it kind of sounds like when you get an apartment, it should reasonably be.
Reasonably? What does that mean?
I think it sounds like contracts, so I'm incorporating contracts. Should be reasonably suitable to maintain your life things.
Reasonably suited to maintain your life. Okay, so this probably sounds totally, by your first year of law school, this sounds totally, okay, right? This is what you're used to. Reasonable standard, safe, clean fit. But imagine you're a building inspector, right? You're not a court. You're a random building inspector. And you get a call from, Miss Hilder saying, hey, you know what? I'm in this apartment and it's not nice. Come on by. And then he goes, whoop, checklist. Well, safe, I don't know, fit, I don't know, whatever. There's a lot of subjective determinations, right? Jeremy, you want to?
Would they, maybe in the statute, would they put possible examples?
Yes! Oh, bingo, 100%, gold star, right? When you write a statute, you can be specific in ways you can't with a common law decision. So for example, I don't know, you can have no more than X number of square feet. You have to have flooring that's in good repair. The electrical work must be in every room. You must have running water. The sewage must be kept. I don't know, I can keep making stuff up, but housing codes. If you have exposed electrical outlets, that's a fire hazard, right? You can, in a statute, spell out very specific things that are necessary. And you can also say in a statute, if there's a exposed electrical outlet, the landlord has 30 days to fix it, right? You can make very precise things, building codes. The toilet must have 1 gallon of water to let it flush. I don't know, whatever the standards are. And with a statute, you can do that. You can have committees, you can have hearings, people can vote on this stuff. You can have experts come in and say, okay, this is really necessary for housing, but that's just a luxury. We don't need that, whatever that happens to be. But when you have a judicial decision, you can't do any of that. When you have a judicial decision, all you can do is simply say, clean and fit and safe and reasonable. And a landlord has a reasonable period of time to fix it. This is awesome for first-year law students. But if you're actually a building inspector or someone living in one of these crappy apartments, that's not very satisfying. You can't go say, look, this toilet only has 8 ounces of water. It needs 4 gallons or whatever the standard is. You can point out specific things that are wrong. So this is not necessarily, this doesn't resolve the case, but I want you as law students to realize that there are things called statutes. They exist. Legislatures are capable of making laws. It's not necessary for courts to do it. Indeed, when they do it, they often don't do it very well. Because you can imagine in this situation, you have these broad terms like safe, clean, whatever, have fit, and that doesn't resolve these actual disputes that people have. So as a law student, you have this natural urge to say every problem must be resolved by a court because that's all you know. All you know is judicial decisions. But that's not the case. And in many states and cities, they've enacted housing codes. They didn't need a court to apply this warranty in. And the state can say as a matter of law, we are telling you before you sign this contract, you are required to put these terms in. Here's a checklist of things you have to fix when you move in. You can't have exposed paint. You can't have exposed outlets. The plumbing must work. Check, 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 check. Whereas this judicial decision is like, oh, whatever. Let's hope that some trial judge in Vermont knows what fit, clean, and safe means. And those are terms which people can disagree on reasonably. So keep this in mind. Just keep this in mind that the answer is not always courts. I feel like I'm teaching a different class today, but indeed, that's often perhaps the better answer. Democracy occasionally gets things close enough to right. Yes, Hunter?
Would the legislator actually be able to provide relief for this person? Because it seems like the judicial decision is actually able to address this person.
Are you asking about retroactivity?
Yeah.
Yeah, so we discussed this case before, but legislators can make, well, there can be some stuff done with retroactivity, but it's more difficult because of grandfathering.
Right. And I guess my second.
Well, okay, actually, let me answer your question like this. So generally speaking, legislation is not retroactive, okay? There's actually a clause in the Constitution, which I hope you've also called the Contracts Clause, which on its face prevents the impairment of contracts by state governments. So that actually does impose some check But the flip side to that is, generally speaking, courts are not supposed to retroactively amend contracts either, but they do. So perhaps in the case of Ms. Hilder, a judicial solution was her only option. But had she lost, a legislative option would still remain. Now, this is what lawsuits don't get, is that after the decision, there's a remand. Stuff happens afterwards, right? So even if, assuming the court hadn't ruled the way they did, the legislature still is capable of fixing the law. Now, again, the flip side is a legislature inclined to do so? Right? This is sort of a representation reinforcement, footnote 4 type argument, right? Are these poor people able to lobby the legislature to get these sorts of laws passed? Maybe, maybe not. Are the landlords who stand to profit from this able to prevent laws like this being passed? Perhaps. So maybe the courts do serve a valuable function of imposing a warranty the legislature would not enact. So there certainly are both sides to this coin as well. Hunter?
The second question was if the court had actually done a full analysis as opposed to just essentially a cursory adoption. Would that not have set some kind of standard?
What do you mean a full analysis?
So, in other words, if in dicta they had started listing out examples of how this could actually.
Now, would that read like a judicial decision? Or would that read like a statute?
Well, I mean, in dicta, they can do whatever.
What do you mean dicta?
So, anything that isn't the whole thing.
I understand what the word dicta means, but if it's dicta, people aren't going to follow it.
I mean, it would be a guidepost, but not.
So I see what you're getting at here, right? Could the court effectively write a decision that looks like a statute? Sure. Respectfully, that's not an act of judicial decision making, right? They're not simply making common law; they're setting standards, and we can debate rules and standards till the cows come home. But you will see decisions in property too, from state supreme courts, where they write property decisions that look a hell of a lot like a statute. And I think that becomes somewhat problematic.
Yeah, so they're not inclined to do that.
No, because then that gives it away what they're actually doing. They're actually really writing the statute. Jessica?
I understand the point about the need of statutory regulation. It seems to me, Hilder, that this actually kind of like came before the statutes, or that's not the case? Because they
What do you mean came before? The trend moving towards this?
Correct. I mean, they say, okay, we overturn this common law view about, when you lease, you're leasing more than land to farm than like the premises itself where you live. Nowadays, people are looking for like city dwelling, shelter.
Yeah. So Jessica's point is, I was actually going to get to that very next. The court says there's a trend, right? And there's always this trend. And this trend is moving away from these sorts of harsh common law doctrines towards these more modern, generous doctrines where they incorporate other doctrines of contract and tort into it. So the court is absolutely following the trend which they themselves started. Right? Right? I always chuckle when the court says there's a trend, because that trend was started by another judge who also identified a trend, by another judge who identified a trend. And if one judge does it, oh, there's a trend, right? And then, oh, there's another trend, right? It's you can always find a trend when you have 50 states and 50 state courts doing stuff. So, I mean, sure. Yeah, I mean, there's a trend. I don't know, the law's trending in this direction because other judges said it was trending in that direction because another judge said it was trending that direction. You see that it's circular, right? But when you just read it, it's like, oh, wow, all these decisions making, yeah? I mean, they don't mention the other 48 states that haven't done this, right? That's the other trend.
Persuasive, right?
Right. I mean, if they identify three or four states that have done this, they've omitted the 46 states that haven't. But there's a trend, right? Common law is an interesting thing, how it develops. And this doctrine, indeed has taken over, but it's a fair repudiation of this idea that property law should be premised on this notion of the Middle Ages, and liver season and all these other sorts of things. Okay. Now, I think you're up next, actually. So, to Hunter's point before, they do have some dicta, right? Jessica, what kind of factors does the court say that lower courts should look to when defining this implied warranty of habitability? They list a couple factors.
I'm not sure. I mean, are we talking about not damages, right?
No, no, not on damages yet. They list a couple of factors that can be considered.
The notice that they have given the landlord that they haven't like acted on it? No.
No, no,
I'm
no.
not sure.
Serenity?
I'm not sure.
Bianca?
Substantial violation of the housing code.
Oh, substantial violation of housing codes. Wait a minute, Bianca. If this city already has a housing code, then why do we need this implied warranty? If it's already a housing code, why do we need this judicially created remedy?
Maybe the housing codes aren't up to the reasonable person standard.
Well, that may be true, but why doesn't Ms. Hilder start with suing based on the housing codes?
Maybe they don't cover what's wrong with her situation.
Yeah. Lily, what do you think? If there's already a housing code in place, why do we need this judicially created remedy?
In the opinion, the court said these codes and standards really provides a
starting point, right? So think about this, right? The codes which the legislatures themselves have adopted are inadequate. Going back to the democratic point, right? The very codes that the legislatures have adopted are inadequate. And let me take that one step forward. Not every city has a housing code. Some states haven't even deemed it worthy to create a housing code for one reason or another. So indeed, I think Lily and Bianca are correct. The housing codes are merely starting points, okay? But there's a more fundamental reason why they don't want to rely on the housing codes, right? Brian, I don't know if you have experience with this, but can you imagine, assuming there was a housing code in the city where they are, in Vermont, what remedy would then Miss Hilder have had? If assuming there was a housing code, I don't know if there was, but let's just assume for a moment. What would a remedy have been?
Well, she could have gone to court if there was a code.
Assuming there was a code, yeah. What do you think she would have done?
She could have taken the landlord to court and sued him for whatever specific damages.
Okay, and then what would the outcome of that proceeding have been?
Since there were specific, assuming there have been specific violations, probably been in the tenant's favor.
Okay. Now, you said something very important. You said Ms. Hilder would have taken the landlord to court and sued, right? What does it take to sue someone? I'm looking at a room full of them. Sorry?
Arm damages.
Oh, no. I'm looking at a room full of them. A lawyer, right? So the way housing codes is this, right? You go to the housing code office, say, hey, I'm living in this piece of crap apartment, and the guy's like, all right, that sounds good. File this report. Okay. All right, we'll send an inspector there in 6 weeks. Okay. So you wait 6 weeks. The inspector comes and he writes a ticket. And he says, okay, Mr. Landlord, you need to bring these premises into compliance in the next 60 days. Okay. Landlord ignores it. They give another 30-day warning. You have 30 days before we fine you. Okay, doesn't do anything. Okay, they issue a fine. Landlord ignores the fine. Okay. Then they bring a proceeding against the landlord to basically penalize the landlord. Miss Hilder is still living there, and she has no relief. And even assuming the thing goes on for a year, she's still there. And then finally, after nothing, she brings suit under the housing code saying, you didn't do this. She has to go hire a lawyer, right? Pay money unless there's a legal aid attorney for her. And then that proceeding may take 6 months, right? Everyone see what I'm getting at here, right? The building code issue does not provide any sort of immediate relief to Miss Hilder. It simply can't, because there's inspections and notices and warnings and ticket. This process can drag on. Not that there's anything right or wrong with it, but it's a somewhat time-consuming process. Okay. So Jamie, tell me, sir, how did this proceeding differ, the proceeding we have here? Because Ms. Hilder is making the exact same sorts of arguments about the crappy apartment, but how did the posture of this case differ from the one we just discussed a minute ago? In what context did Ms. Hilder raise these awful conditions in the apartment? Not in this lengthy proceeding for the building code, whatever. How did this come up?
Just what the formal
Well, who brought suit against whom? Who filed the lawsuit?
Hilder.
No. Who sued whom? No. But what was the context, though, of the suit? What did it arise from? Did it arise from a housing code suit? How did this suit arise?
Sorry, I'm not sure I followed.
Okay, let me ask the question differently. Let me ask a question like this, okay? Let's assume for a moment, right? Let's assume that Ms. Hilder wasn't as good of a tenant as she was here. Let's assume that you had these deplorable conditions and Ms. Hilder simply moved out and she stopped paying rent. What could have happened at that point?
If the landlord wanted to, he could have sued her.
Ah, and what would Ms. Hilder have said in response to that suit?
That she was constructively evicted.
Okay, so if she had actually moved out, she could have said she was constructively evicted. Okay, let me ask you a different hypothetical. Let's say that she stayed in there, but just stopped paying the rent. She stayed in there and simply stopped paying the rent. And then he sues her for the lost rent. What else could she have said now?
Maybe she could claim a credit for the money that she's paying.
Because of what? You're really close. What could she have raised? If someone sues you, what do you usually respond with?
Countersuit?
What?
A counterclaim?
A defense, right? What would a defense have been?
The place was in shambles.
Okay. So follow me here. This is I didn't ask it right the first time. I apologize. So between what Brian and Jamie just said, without the implied warranty of habitability, right? The only way that this can be raised is if the tenant sues the landlord, and that's something that's very expensive. Okay. However, with the implied warranty of habitability, the tenant, if sued, can raise the conditions as a defense. Ah. Okay, I didn't do it right the first time. I did it right the second time. I said it again. I explained it the right way. Under the common law, the only way that Ms. Hilder could have brought this issue up was if she filed suit against the landlord and said, look, there are these bad conditions, but that requires a lawyer, legal counsel, it's expensive. However, with this implied warranty of habitability, if she's sued for back rent, then she can raise as a defense. So one of the key moves of this implied warranty of habitability is shifting the burden of proof, right? So now it's not up to the plaintiff to bring this suit. The tenant can now raise this if she's sued. And that's actually a fairly significant change. This allows the courts, outside of this building code proceedings, to consider the housing conditions. And the courts can make these decisions without having to go through this entire lengthy process. So this implied warranty is actually fairly significant. Because now, when the landlord sued for back rent, tenants say, no, I'm not paying this because the conditions are bad. They can seek rescission of the contract or reformation or damages in various different calculations. That's what this implied warranty actually enables. It enables the tenant who gets sued to also raise this. Now, in this case, Jimmy, you're right. I was actually asking hypo, which wasn't the thing in this case. In this case, the plaintiff actually sued. She must have had a good lawyer, right? But it doesn't need to be like that. So perhaps one of the reasons why evictions take forever, which we discussed a few weeks ago, is because if a tenant moves, if a landlord moves to evict someone, the tenant says, wait a minute, implied warranty of habitability. These conditions are not valid. The reason why I'm not paying my rent is these are crappy conditions. And then the courts will litigate that. Right? This is why these things can take 6 months to a year, because courts have to decide, has the warranty been actually violated? Raises a defense, and that runs the clock. Okay, everyone get that point. This now allows the tenant to raise this as a defense, which can prolong the removal proceeding or actually delay any sort of a demand for back rent. Get that? So, Jamie, you're right. I'm sorry. I said it wrong the first time because I was thinking of the hypo, and then I flipped it. But I appreciate you correcting me. It's always well done. Yes, ma'am. That was risky at the time, though. I'll answer your question in a second. But at the time she was there, had the court yet created this implied warranty? No. So, but the next tenant, right? So imagine this, right? Let me answer your question like this. If you're a lawyer, right? Say you're a legal aid lawyer, and your client walks in and says, listen, my landlord is awful conditions, there's paint peeling, there's sewage. Can I just stay here and not pay rent? And then if you're the lawyer saying, look, it's always risky, but I'm pretty sure that if he actually moves to evict you for not paying rent, we will raise as a defense a violation of this implied warranty of habitability. And based on these awful, awful conditions, the judge may say, you know what? The rent he was charging was way too high. We're going to reduce the rent. Maybe not to zero, but something awfully close to zero, which then you can pay later. Again, it's never perhaps good advice to your client not to pay rent, but if in their situation where they can't vacate, for whatever reason, family, whatever, they can't leave, then with this implied warranty in place, it may not be an idiotic decision to actually just stick around. But again, don't advise your client to this, but you can imagine how if a tenant understands this, and they, well, screw this, not paying my rent. I'm going to deduct from my rent what it costs to keep these premises habitable. Does that answer your question?
Yes. Again, it's like this example, a landlord wouldn't want to sue the tenant because they didn't have any money. So would you ever have a situation where the tenant's not paying rent?
Well, it's not just for money, though. It's also to remove them from the premise. Because, like, remember, she's holding over. She's not paying rent, and she's still in the unit. So you can imagine the tenant, the landlord doesn't care about the money. He cares about removing her, right? We don't have self-help anymore. You can't literally, like, change the locks on her. So the landlord may say, listen, we'll just simply move for a summary ejectment. Right? No, there's like 20-day procedure like we have in Texas, right? And the tenant's like, well, you know what? You can't remove me because you're violating the implied warranty of habitability. And then that makes the 20 days into a couple months. In which case, eventually the court may say, well, your rent is not $500 a month, it's $300 a month. Pay $300 a month in back rent, and then the tenant just leaves, right? But it prolongs the process. That answer your question? Thank you. Other questions? Yeah, everyone connect this in your notes when we did the summary ejection, right? Because when you have a summary ejection, it's supposed to be a fairly speedy process. One of the things you can raise is an implied warranty violation, saying the reason why I'm not paying my rent is that these premises are not up to code. Now, generally speaking, again, almost every city has a housing code, at least Houston does for sure. And you don't need to necessarily rely on the implied warranty. But in jurisdictions that don't have it, you can raise that as a defense. Okay. Everyone get that? Good. So the court's analysis is more or less what you expect. It incorporates contract doctrine. Okay. They're bringing all these doctrines from contract about notice and fair dealings. And this is the general trend of the law. Much like with contracts, the court explains, you have remedies. Okay, so what could Ms. Hilder have done? She could have withheld rent money and said, I will use this rent money to pay for whatever damages. Now, again, that's a somewhat risky move because what the court finds that it wasn't proper to withhold the money. She won't get that back and she'll owe the rent. So it's always risky for a tenant to pay out of her pocket whatever is needed to fix something. Okay. The courts also differ on how to calculate the damages. Some base it on the rent being paid versus the actual rent that's owed. Some base it on the rent being paid versus the fair market value. Query whether this apartment, I have a picture up here, was it worth $0? The book asks this question somewhat hypothetically about what is the value of this living condition? Can you even live there? Is it actually literally $0, or is it a roof? I think as someone said a couple minutes ago, it's a roof over your head and not much more than that. Yeah.
I know that there is a downside to having absolutely no one living there, because if no one's living there and no one's running the heating, no one's running the pipes, it can actually damage the premises. So you could argue that by me being in there, I'm a benefit.
You're creating money, yeah. But you don't need money.
Yeah.
You're paying me to live there, right?
Yeah.
There you go. Sure, why not? But I suppose you're like a house sitter, right? Make the argument, I guess. I don't know. Other questions? One interesting note that arises in this case is that of punitive damages. And I'm sure you guys learned in contracts law, we don't have punitive damages. You learned that, right? Ditto, in property law, we don't have punitive damages. That's not a concept that, at least for this decision or this time period, was even known. You've seen punitive damages in tort, right? If you commit a really egregious tort that's like, shocks the conscience, is absolutely awful, that the courts can award punitive damages, right? So, Sean, why does the court say that punitive damages could have been awarded, maybe could have been awarded in this case?
Because of the intentional conduct.
Okay, what do you mean intentional conduct?
The landlord was aware of everything and just ignored it.
Okay. So the court describes that there's this demeaning of the plaintiff and a wanton disregard of plaintiff's rights. Sounds like a Kennedy opinion about the dignity interests. But they said there's bad spirit, there's bad blood, and all these sorts of awful things. So indeed, punitive damages are now permissible for violation of this implied warranty of habitability. I'll give you another example of the difference between a judicial implied warranty and a statutory implied warranty. Varvara, do you think that the legislature would allow punitive damages for a violation of a warranty? They created one by statute? How do you think most legislatures define damages? Get to guess. No, I mean calculate. Defines the wrong word.
Okay.
Do you think they say, well, whatever is wanton hate, we'll just let the jury decide? How do you think legislatures define penalties or calculate penalties?
They would put it up front by what would be reasonable.
Dollars and cents, right?
Yes.
So if indeed the legislature creates one, there's a dollar and cents. So it says every violation of building code is $3,000. Period. Second violation is $5,000. Third violation is 10. Whatever the number is, right? There's a specific number. But this judicially created remedy is compensatory damage for pain and suffering, and punitive damages because this guy's evil. That's perhaps a very distinct difference between the legislative and the judicial solution. Okay. But alas, waiver, right? What's waiver?
Waiver is when you waive your right to claim that sort of.
What happened in this case? What was the waiver in this case?
Not sure, I don't remember.
With respect to the punitive damages, what was the waiver?
That she lived in those conditions.
No. Exactly.
That she continued paying.
No. This is her lawyer's fault. No? Okay. The number one rule about appellate law, any argument that you don't put into your appeal, you waive. Let me say this again. If you do not put an argument into your appellate brief, it's gone. You've waived it. This is the lawyer's fault, not Ms. Hilder's fault. They raised this argument in the trial court. The trial court addressed it, denied it, then they went on appeal. They did not raise the issue on appeal. This issue is even more fundamental. If when you bring a complaint, you bring your initial trial court documents and you fail to raise a claim, and then you appeal it, you cannot first bring an issue on appeal. Okay? Appellate courts will not look at issues unless they were raised below. And I know you haven't taken evidence yet. You'll take it next year. But when you're actually in a trial, you always see in law and order, objection, Your Honor, objection. And notice they keep standing up saying objection over and over again. The reason why they do that over and over again is because if you fail to object even once, you can be seen as waiving your appeal. So you basically have to say objection, objection, objection every time, no matter how annoying it is, to make sure your client doesn't waive it. Because the worst thing you can tell your client is, yeah, remember that claim for punitive damages? You could have just won a couple $1,000s. I forgot to include that in the brief, so you don't get anything. That's a very awkward conversation to be followed by a malpractice lawsuit very soon thereafter. I'm not joking, right? Do not waive your issues. No matter how obnoxious it is, put everything in there. There's often an expression called the kitchen sink pleading method, where you throw everything you can possibly think of, even if it's wrong, right? Not if it's like, Rule 11 sanctionable stuff, but put stuff in there just in case it actually makes sense later. Because you don't have any idea how many times when you're an appellate lawyer and your opposing counsel makes an argument like, wait a minute, he didn't make that argument below, waived. And the court loves waiver, right? Why do courts love waiver? They don't have to do anything. They say the issue has not been properly raised before the court. It's deemed waived. Goodbye. Dismissed. Case dismissed. So even if you're not an appellate lawyer, if you want to do trial law, object to everything. Give your client a solid record that if the case goes up in appeal, you are not the one who hurt your client's case. Make the objections. They don't have to be good objections, right? Even if they're not very good, just object, put on the record, and then let someone else deal with it later. Okay? Yes, sir.
Is that sort of omission considered some sort of malpractice? Or?
Yes. Oh my God, yes. I mean, if you're a lawyer, right, and your trial court denied punitive damages, and then you appeal up to the Court of Appeals, and you forget to raise the punitive damage claims, and then the court says, well, we would have given punitive damages, but you forgot to raise it. Oh yeah, you're gonna get sued. You as a lawyer are going to get sued. It's actually an interesting area. These are unpopular people, lawyers sue other lawyers. I don't say that lightly, but there are specific lawyers who specialize in malpractice prosecution. Because if you imagine, they're not very popular. Because it's basically telling other members of the bar, right, their colleagues, you screwed up. So if you actually Google malpractice lawyers, it's a very select niche bar. You also have malpractice defense lawyers, lawyers who defend fellow lawyers against malpractice charges. This is why all of you need what's called malpractice insurance. As an attorney, you're probably going to get sued at some point. And you're required, not required, but it's strongly recommended to keep a certain level of insurance. That way you don't lose your house and your family's business and everything else if you screw up. Most of the time, lawyers don't actually bring these claims unless there's a lot of money. In this case, we're talking maybe a few $1,000s. It's probably not worth it, but you can imagine if this was a serious tort case with millions of dollars in a personal injury case, and the lawyer just forgot to plead the punitive damage claims and appeal, and the client lost millions of dollars, yeah, they're going to sue. Especially when the court said here, we would have given you these damages, but you forgot. That's like when the court actually makes, occasionally judges will actually write some opinion saying, you had this argument, but your lawyer screwed up, and lawyer, we want you to show a copy of this to your client. Actually there was an Easterbrook opinion, we'll get to the Easterbrook, but I've actually seen an opinion of his where he says, in the order, the attorney is required to certify to the court they provide a written copy of this opinion to his client, which is basically saying you can get sued. And that's not just telling him. That's saying a notice to the entire bar saying, hey, if you're a malpractice lawyer, go call this guy. He's got a case coming up, right? Yeah, Cody.
Just to drive the point home, I heard of a case in New York where the guy was so negligent that the court made him go to the partners in his firm and have each of them sign a copy of the order to make it very clear that everyone knew how terrible he was.
This is like when you're in elementary school and you fail an exam and your mom and dad have to sign it, right? Basically, right? I hadn't heard that one, but that occasionally because judges can't bring legal malpractice proceedings, but they can make such a big fuss that it becomes obvious that someone else ought to. And indeed, the bar itself can bring disciplinary proceedings against a lawyer. They don't need a lawsuit to be filed. The bar itself can bring investigation. So I guess it's fitting for the last day of class. The most important thing you have as lawyers is your integrity. Nothing else matters more. When you put your name on a pleading, I don't care if it's to a court or to the SEC or to an agency. I don't care who it's to. When you put your name, when you sign something, you're putting your entire career in the line when you sign that. This is not a joke. And taking half-assed measures and not doing a good job, you can lose your law license. You can be suspended, and good luck getting a job after that. Think very carefully when you put your name on that line. You sign your name. It's a very solemn act. And I mean, I'll give you an example. I recently put a brief to the Supreme Court, and I had one sentence where I said, Congress did such and such in 2015. And then I was reading about a week later. I'm like, wait a minute. Oh, no, that's not right. Congress had considered the same bill with the same name in 2014 and 15. The one 14 passed, one 15 hadn't. And I inadvertently cited the 15. You know what I did? The very next day, I sent a letter to the Supreme Court saying, I apologize. I made a mistake. I confess error. Please accept this. You know, it was really a citation error. It was a blue book mistake. But the way I wrote it was I was citing a bill that had never passed. I said, look, here's the actual one. And you know what you do? You copy everyone else in the case. There were like 70. This was in the immigration case, the Texas immigration case. There were like 75 of the top appellate lawyers, and I sent a letter saying, I screwed up. Here's the mistake. Right? Talk about putting the partners of your firm. I CC basically every lawyer who followed this case saying we screwed up. Okay. But you know what? If anyone ever looked at that brief and said, wait a minute, Blackman put the wrong citation, then that'd be my name in the line. So as attorneys, you always have an undoing duty of candor to the court. And if you ever discover that a mistake was made, raise it immediately. The worst thing you can do is have the court call you on it, and then it's like, oh, well, I didn't know, or I knew but didn't think it was a big deal. That's how you get in trouble. Yeah, I felt awful. I was reading a couple of days after it was filed, like, wait a minute, that's not right. The citation was off. But and the next day we sent a letter. We didn't even wait a day. So whatever that lesson's worth, your name means a lot when you sign it. Okay. Yes.
I had questions about the punitives. You said contract law we don't have punitives, and also property we don't have punitives.
Not in, well, now we do.
Oh, but now we do. Okay.
Yeah, court said so.
Okay.
Well, as a matter of common law, the notion of a punitive damage in property it wasn't the thing. We didn't have it. But courts have read this into various elements of the landlord-tenant relationship. Okay. Yes, Pierce.
So did the attorneys in this case just not know that they even could raise punitives?
Maybe they screwed up. Maybe they thought that punitive damage, such an outrageous argument, wasn't worth raising. I mean, there is a constraint, which, I mean, doesn't really matter to you now, but you have word limits in briefs. I love students who complain about the word limits on my exam, 1,000 words, whatever it is. Briefs to the Supreme Court like 7,000, right? You guys are fine. You have so few words that maybe to economize, you omit claims. Also, sometimes you don't want to raise a claim that will hurt you because you want your appeal to be as strong as possible. But by deciding not to raise a claim, you put yourself at risk for this. Yeah.
Would you say most states have adopted the liability?
I think the book says like only 2 or 3 states don't have it. And virtually every state has adopted it through either a judicial decision or some sort of legislative solution. So, you know, virtually every state has it at this point. What else? Okay. I want a brief note on retaliatory eviction. Retaliation is a concept that you will see quite a lot in the law. And you often see it in the employment context. So the example looks like this. Some employee is denied a promotion. Okay, that employee makes a complaint saying, I was denied promotion because I'm a female and my boss doesn't like girls, whatever, right? A week later, the employee is terminated after making this complaint. And the boss says, you've been terminated because you've been missing too many days. You have absenteeism, right? You're actually missing days of work. So let's say, assuming that the employee had been absent a lot, maybe she'd missed, you know, more days than she had sick leave. And generally speaking, if you have a cause for termination and you actually were absent, then you can fire the person. You don't need a reason. But because the termination came after this formal complaint of gender discrimination, Then the employee can say, wait a minute, you didn't fire me because of those absences. I've had those absences all along. You fired me as retaliation for making this complaint against you. Okay? And indeed, in employment discrimination, the retaliation claim is often stronger than the discrimination claim because it's very hard to prove that someone acted based on a gender bias, whatever else. But you can prove saying, I made this complaint and a week later I got fired, right? That's something you can tell a court about. That's a little bit easier to convey. So the doctrine of retaliation applies equally in the housing context. So imagine this, right? Let's say you're in an apartment and it's in really bad shape. And you tell your landlord, can you please fix this? He's like, okay, I'll do it. He never does. Fix it, never does it. So then you say, you know what? I'm going down to the housing office and I'm going to file a complaint against you. And you go and you file this complaint. Landlord finds out about the complaint, moves to evict you the next day, saying, whoop, they had a dog. Dog's in violation of the lease. They've had the dog for 6 months, never bothered me before, but you know what, that dog, can't have a pet in the unit. Okay? The landlord raises this, moves to evict the tenant. The tenant can say, no, this is a retaliation for my complaint. I have a lawful right to complain about the conditions at this office. I made my complaint, and you can't evict me for it. Okay? With these sorts of leases, the landlord may be stopped. The court may say, you know what? If you're terminating someone's lease within, 3 to 4 months after this complaint, the presumption is that you're doing it because you're retaliating. That won't fly. You can't evict the person. Okay? As long as you're paying the rent, you can't evict them. Okay? So that's this doctrine of retaliatory eviction. Any questions on that doctrine? Okay. Don't worry about the tort stuff. I assigned it only because I think it might be interesting for your tort studies, but the middle chunk of the reading is all about tort stuff, and I'm not too concerned about it. So don't worry about that either. Okay. Any questions about that? Jessica?
In retaliation,
I'm sorry. Say again. I didn't hear what you said.
In retaliation,
Oh yes.
if I'm not mistaken, what's the paragraph that, if you're going to evict them after they have complained, you still have to, you have to give them some time in order for them to find a suitable place?
Yeah, the laws vary by state. And I don't particularly care about this point, but some states, after there's been a claim of retaliatory eviction, there's almost like a cooling off period, and you have to wait a certain period of time. And in some places, you can't evict them at all.
Okay.
So that this varies by state law, but the general notion is after you make an official complaint, the courts presume that the reason why you're tossing them out is because they made that complaint. Almost like a whistleblower protection, if you think about it. Mm-hmm. Everyone know what a whistleblower statute is? Like you blow the whistle, you say, oh, there's bad stuff going on here, and then your boss miraculously fires you. Well, there's presumption that you were fired because you were shining light on this sort of bad activity. Okay. All right, last case. What's I up to? You next? Okay. Or did you? Okay, very good. All right, Landon, you want to tell me, please, the facts in the Chicago realty case?
Yeah, the city of Chicago passed an ordinance that sort of, I guess, it was about the implied warranty and habitability, and kind of shifted more of a burden on the landlords. So the landlords collectively sued the city on constitutional grounds.
Okay, good. So the city of Chicago enacted this ordinance that did a lot of things. So it codified the implied warranty of habitability, it imposed new responsibilities on the landlord, required the payment of interest on security deposits. It said that you need to hold the deposit in an Illinois bank. This was a nice kickback for local banks. That's all that was. It said that the tenant can withhold rent if there was some sort of a damage to the apartment. The tenant could also make repairs and then subtract that from the rent. It prohibits late fees on late rent up to $10. And the landlord who seeks to evict the tenant after he's exercised some sort of right is presumed to be retaliation, right? So this statute, imagine that, codifies a whole host of judicial decisions, right? Legislatures can do that. So you've had a lot of, these sort of disparate judicial decisions one way or the other. And now the Chicago City Council steps in and votes for this statute, which codifies them. A number of landlords bring suit, arguing that's unconstitutional. Probably that was a taking, a violation of due process, probably a contract clause violation. There's probably a whole host of various claims brought. And the Seventh Circuit dismisses them. This case is a fun one to finish the semester on. Let's see. Graham, tell me, sir, generally speaking, on an appellate panel of 3 judges, what's the majority opinion? Well, if there's 3 judges, right? How many judges does it take to get a majority opinion? Sorry?
Just 2.
2, okay. So it makes this case funny, right? Is that there were 3 judges. And all 3 of them agree that the Chicago law is constitutional. So one judge, Judge Cudahy, writes, I think this is constitutional, but this other stuff in the opinion, this wasn't litigated, and it's superfluous. But then you have probably 2 of the smartest judges in the federal judiciary, Judge Posner and Easterbrook. I will wager that their collective IQ is higher than most 3-judge panels. Yeah. Judge Posner, I mean, I'm sure you know about him. He basically writes a book a year. He's a compulsive writer. Don't get into an argument with someone who can write faster than you can think, because he writes that quickly. It's startling. And also, Judge Easterbrook has a supersonic IQ. He used to work in the Solicitor General's office, and he would memorize citations, a case at the top of the citation. Oh yeah, that case was in 525 U.S. 413. Like, he'll know the page where a case is on. These people are insanely smart. They were both appointed by President Reagan to the Court of Appeals. They were both professors at the University of Chicago Law School. And they were both leaders in the so-called Chicago School of Economic Analysis, the idea that law and economics should merge, and the court should apply various principles of economics in ruling. Judge Posner famously wrote an article, somewhat facetious, arguing that selling of children should be allowed if the price is right. That there should be a market for the sale of children. That may have kept him off the Supreme Court. I'm only slightly joking, but he firmly believed that. Interestingly enough, he's become much more of a statist in latter years, but at one point he was fairly a libertarian. But when you have Posner and Easterbrook on the same panel, they write this lengthy opinion. And they say, well, you know what? There are 2 of us, and there's 1 of you, so we're the majority opinion, even though we're reaching an issue that has absolutely nothing to do with the case and was not litigated. So why is this in your casebook, right? Why did I make you read this last few pages before I let you go home for the semester? Not really. But why? Because it actually does what Bastiat wants you to do. There's a seen and the unseen cost. So on the face of the statute, it provides all these protections for landlords. I'm sorry. Oh, yeah, actually. On the face of the statute, it provides all these protections for tenants, right? You reduce the late fees, you make them pay interest, you make it easier for them to withhold rent. Like, these are all awesome things for the tenants. But Judge Posner, as he often does, peels back the onion, 1 layer at a time, and argues, wait a minute. There is something else going on here, right? There's something else going on here, right? Cameron, what are Posner and Easterbrook talking? What's actually motivating the statute? What's actually going on here? What's Posner's argument? What does he explain?
That, like, when the housing is artificially priced, the landlord gets costs raised and that hurts the tenant.
Okay, good. Graham, let me ask you the question. I'm sorry, Cameron, let me ask you the question a different way. This law imposes a host of new costs on the landlords, right? They have to give interest. They have to reduce penalties. They have to make it harder to evict someone. They have to provide better conditions. What does that do to the cost of housing? And who bears the cost of those increased fees? Okay. So what Posner says is like this. It's awesome for a legislature or a court to simply say, let's make it better. let's make housing great again, right? Let's improve the living conditions of these tenants, and it'll be awesome. But what Posner says is, wait a minute. Who bears the cost of these better conditions? And the answer, and this is somewhat incontroverted, is the other tenants. You see, landlords don't go into the business of housing to be nice, right? Adam Smith said 200 years ago, the baker doesn't make bread for the benefit of others. He makes it to make money for his family. So if the landlord has all these new costs, they will shift those costs back to the tenants in the form of highest rent. In the form of highest rent. Notice the statute is not a rent control statute. It does absolutely nothing to control the cost of rent. Nothing. So simply, great, you have lower fees, you got to get interest, we're going to charge you more rent. And this is an unseen cost. You'll never see that cost increase because of this. But landlords know how to internalize these costs. Proposer makes a more foundational point, right? Natalie, which class of people does this most impact, this sort of law? What does Posner say?
Well, they refer to them as marginal tenants, but they were referring to, it'll actually consequently displace poorer class and the middle class.
Why? Why are the poorest hardest hit here?
Well, because landlords are going to be more inclined to strictly, I guess, filter out who they're then leasing to if they're going to be charging higher rent. And then that will consequently lead the poorer class to struggle with trying to find housing.
Excellent. Excellent answer. Very good. So what Posner effectively explains is that even though this is a law on its face meant to help the poorest, it will hurt them the most. Why? By making housing more expensive, it prices them out of the market. By making housing more expensive, you price them out of the market. And middle-class people will now be able to afford these better conditioned apartments. And oh, by the way, Posner said, many of these rental units may become condo. Sell them. What's the point of having all these expensive fees if we can't recoup them? So if you will, think back for a moment to Miss Hilder, where we began the class. Right? She needed that apartment. She needed to live there. She had nowhere else to live. After the implied warranty of habitability was kicked in, do you think her rent would have been $140 a month? No. It would have been double that, market rates. What if she couldn't afford $280 a month? Where would she have lived? I don't know. Right? This is Posner's basic point. All of these efforts to try to make the conditions better have the end effect of raising rents and making it harder for the poorest to find housing. Posner argues. As a footnote, though, they note in the notes after, those who read it, housing prices didn't actually increase after this. So this is one of the difficulties of Posner's, shall I say, self-guided tours of law, is that he often makes arguments that are not correct. He writes a lot, but there's not a lot that's right. I've had my things with him. But it turns out he wasn't right. But the economic principle, though, was right in theory, at least, that when you make housing stock more expensive by increasing the living conditions, it makes it harder for the poorest to afford these sorts of things. So Posner says this is not in the interest of poor people, right? The only people who benefit here are probably Illinois banks for getting all this new money, and there's lots of graft involved. Some questions? Yes?
So what's the solution under that kind of theory? Because, I mean, using the example from the previous case, you need a place to live, but having these protections will make it more expensive. So the only solution seems to be to let her live in destitution.
Well, I mean, there are other solutions. There's often government housing. There's government subsidies. There are other ways to do this without with different types of market distortions.
Those also artificially depress the price of the market.
Of course they do.
So I go back to let her be in a destitute place that's breaking and falling apart. Otherwise, everyone else suffers.
Well, market distortions, perhaps, society can decide are appropriate to avoid people living in these destitute conditions. Yeah, Norma?
ultimately Posner, like economically he was correct, but he was kind of looking at this not in a sense like at that. He was actually, I feel like he was correct in a broader sense as far as what was happening as how the law was evolving. I mean, yeah, the rates might have gone higher, the rents stayed the same, but if you think about it, I mean, gentrification happened, and he probably was looking at a more broader side of that.
Maybe he's right. Maybe the long-term Posner's right. I don't know. Yeah.
Seems to ignore the idea that you can price yourself out of an area, and if you increase the rent, it just assumes someone will magically show up to pay that rent. You could very easily raise your rent, and then no one goes there, and you're out of business, and you are demolishing. So if he doesn't take into account the idea that if you raise the rent, you may end up getting no one to actually pay it. So there is kind of a
Or you attract different kinds of tenants,
or
which is the
people
argument.
that have the money to pay for that rent go, I could live there, but I don't want to. I don't like the surrounding area.
Right. I think Posner's general argument is let the market decide this. Don't let this up to legislators who make these sorts of rules. But after all this, he upheld the law. So this entire analysis was, to use Hunter's phrase, dicta. Anything else? Thank you all so much for a great semester. Appreciate it. Thank you. Thank you. Thank you. Thank you. Thank you very much. I will see you all on May 9th. Thank you.